Okay, so I have two questions for all of you. First, how many in this room would like to see an end to abortion? Okay. And second, and you don't have to raise your hand, but just think about this. Can we all say with full assurance that we've done everything in our power to end it? My name is Brenda Biskey. I'm a wife, a mom, a constituent, a lover of life, truth, liberty, and these beautiful documents that we heard about today called our constitutions. Thank you so much for being here and being willing to listen to us all. It shows courage, and we as citizens greatly appreciate it. My husband advised me that when I stand in front of you today, to make sure I tell you my why. So here it goes. I'm here because I care, because I'm a mama bear. I'm here because I go to abortion facilities to talk and plead with women, to love them and to offer them hope. I see the actual real-life consequences of legislative decisions happening behind these walls and walls like this around the country. Allow me to say it this way. I'm here today because I've made a terrible mistake. I believe the lie that Roe v. Wade is the law of the land and that I must submit to judicial supremacy and be a good cooperating citizen. My goal for today is that all of you would go home with this question on your mind. Is it possible that we've been hoodwinked for 47 years and that maybe we could have saved millions of lives? Let's dive in. I will cover today why abortion on demand is unconstitutional and therefore unlawful, why it came to pass, and exactly what we can do to truly stop the murdering of innocent preborn lives. I'm here to speak on the case for equal protection in terms of legislative strategy. I'm a former student of Institute on the Constitution. My husband and I had the privilege of taking David's Maryland Constitution course last year, and I highly recommend it. It was a game changer for me, and I'm going to tell you why in a moment. I'm also a longtime friend of Jody's. Together, we do sidewalk counseling at the Baltimore Planned Parenthood. We've prayed together in front of abortion facilities. I volunteered at a crisis pregnancy center that she founded, and I've taken her pro-life engagement course 3 times. Another class I highly recommend to anyone who wants to learn how to effectively engage the pro-abortion culture. I'd like to start by sharing my own experience in relation to pro-life legislative understanding. When I first got involved in the abortion fight, I was so excited. We're going to end this thing. We're the pro-life generation. But there's something about me that sometimes I'm not so sure if it's a curse or a blessing. And that is that it's not enough for me to know the end goal. I need to know how we're getting there. When I learned about our constitutions and our founders' worldview, it was like someone turned the light on for me. And here's why. Just to give a little visual perspective of what Michael and David shared, our founders were pretty smart. They set up a system of government in which checks and balances were established. This was to avoid tyranny, which they were coming out from. These are not choo-choo chains, okay? This is the government, the way it's set up. So we have on the federal level, the U.S. Constitution, and then the branches, legislative, executive, judiciary. These are all elected officials. And then on the state level, Maryland Constitution, same, all are elected officials, okay? All elected officials swear an oath to uphold the United States Constitution. And in the state of Maryland, all elected officials swear an oath to uphold both the Maryland Constitution and the U.S. Constitution. Is that right, David and Michael? Okay, just want to make sure. Okay. So, as we've already pointed out, in terms of the preborn, both of our constitutions explicitly state that no person shall be deprived of life. And we heard that life starts at fertilization. And we also heard that our Declaration of Independence, which is organic law, states that the very reason government was established is to protect our God-given rights, namely the right to life. And that we are created equal, not born equal. And in the preamble of our United States Constitution, these rights are for ourselves and our posterity, meaning all future generations, including our unborn. But this is not what I heard when I first got involved in pro-life work. I remember going to conferences and asking well-known speakers, what is the legislative strategy to end abortion in Maryland? And everywhere I turned, this is what I heard. Roe v. Wade is the law of our land on the federal level. And then on the state level, I heard this. The 1992 abortion law, and this is, probably you've all heard, the ballot thing that kind of made Maryland a sanctuary state for abortion if Roe were to disappear. Okay? So this was the strategy. This is where we were at. And I was told that in order to combat this on the federal level, we need to elect conservative justices. But didn't a conservative majority Supreme Court actually give us Roe? And on the state level, I was told that the way to combat this is to regulate abortion. When we regulate abortion, we decide which babies live and which babies die. Compromise is the key. Because we can't do anything about Roe, so we're left with compromise. Okay? Does this sound familiar to anyone? Yep. Okay. But is Roe v. Wade the law of the land? Or is the U.S. Constitution the law of our land? Does the judiciary have any authority to make laws or amend this Constitution? Or is their role to simply decide cases according to the purpose and principles of this document, the United States Constitution? Does this strategy fall in line with the very purpose of our government, which is to protect our God-given rights, namely the right to life? Did the justices uphold their oath to the U.S. Constitution? So is abortion constitutional? Roe v. Wade violated natural law and our U.S. Constitution in the worst way possible by ruling against the supreme, unalienable, equal right of the unborn child. As we have heard, by every moral and constitutional principle of the founding of our republic, Roe was a lawless decree and therefore a legal nullity. Our founders, as David mentioned, used the term pretended legislation in our Declaration of Independence to describe the lawlessness of the many parliamentary enactments which violated the British Constitution. I believe that if legislators today understood abortion on demand to be this pretended legislation and realized there is no legal authority in anything that violates our God-given rights, then it would be a game changer. Those who raised their hands earlier, I believe you. I truly believe you want to see an end to abortion. But the fallacy of abortion being law of our land has kept our hands tied. We need to learn the truth so we can break free and push back against tyranny. As I stated, under our current strategy, we decide which babies live and which ones die. Again, compromise is key. But what many don't realize is that it was this compromise that actually gave us Roe in the first place. In footnote 54 of the Roe decision, conservative Justice Blackmun stated, when Texas urges that a fetus is entitled to 14th Amendment protection as a person, it faces a dilemma. Neither in Texas nor in any other state are all abortions prohibited. Despite broad prescription, an exception always exists. The exception contained in Article 1196 for an abortion procured or attempted by medical advice for the purpose of saving the life of the mother is typical. But if the fetus is a person who is not to be deprived of life without due process of the law, and if the mother's condition is the sole determinant, does not the Texas exception appear out of line with the amendment's command? There are other inconsistencies between 14th Amendment status and the typical abortion statute. It has already been pointed out that in Texas, the woman is not a principal or an accomplice with respect to an abortion. If the fetus is a person, why is the woman not a principal or an accomplice? Further, the penalty for criminal abortion specified by Article 1195 is significantly less than the maximum penalty for murder prescribed by Article 1257 of the Texas Penal Code. If the fetus is a person, may the penalties be different? In other words, and this is extremely important to understand, Blackmun found Texas to be inconsistent and hypocritical in their argument to the court, because while pro-life legislators argued that the preborn were persons worthy of equal protection under the 14th Amendment, they did not treat their killing the same as the unlawful killing of born humans. As a result of this failure to treat all abortion as murder, the preborn were dehumanized. Blackmun didn't even have to do the dehumanizing himself, only point out that pro-life legislation already dehumanized the preborn by not giving them equal protection. When we begin from the standpoint that we already lost because we falsely believe abortion to be the law of our land, we dig ourselves into a hole we cannot get out of. I believe these last 47 years have proven that. We've moved from criminalizing abortion to celebrating when we pass legislation that allows proper disposing of aborted children or saving an already born child. Meanwhile, pro-abortion supporters moved from safe, legal, and rare to celebrating infanticide after a fully developed child is born. Do-it-yourself abortions are becoming increasingly popular. Every day in Maryland, babies die and are cast into landfills, incineration chambers, and down garbage disposals. Per Planned Parenthood's own annual reports, abortions are steadily increasing, while the amount our government funds them is also steadily increasing. Let me illustrate. Are you still with me? Okay. This is what I call the abortion weed. What happens when we prune a weed? It grows back. It doesn't die, right? What happens to the roots? They get stronger. This has been our last 47 years. Regulating abortion, compromising. So let me just, right here. Sorry. Pour it here. All right. Great. All right, so we've discussed the problem, and now let's talk about the solution. The answer is clear. The only constitutional strategy for ending abortion is to enact and enforce equal protection under the law. This would dig up the abortion weed from the root and pull it out. Moving forward, we must put forth constitutional legislation that not only defines life beginning at the moment of fertilization, but offers those lives equal protection under the law, meaning treated equally at all stages. There are currently at least 7 states that we're aware of that are already doing this. We're keeping an eye on them and watching them closely, so we would not be the first state to propose such legislation. We must allow no exceptions, because to do so would be inconsistent with every unborn life being already protected under constitutional law. We must understand that although rape and incest are horrible things, you don't murder a child because of the crimes of the parent, nor do you advocate the trauma of taking your own child's life on top of the first trauma. We must put forth legislation that holds medical practitioners accountable to include all unborn children as equal patients under their Hippocratic oath, and to exhaust all resources possible to save the lives of both mom and baby should the mother's life be in danger. We must do this while also understanding that as long as the doctor has exhausted all measures in trying, but should the baby die, he will not be charged with homicide. There are already laws in Maryland that protect doctors from innocent acts of medical practice. But here's the thing. We've moved so far away from valuing unborn human life when the child is not wanted that it has become normal for doctors to not even try to save them. That needs to change. Equal protection would treat them as equally valuable patients. We must understand that we cannot say abortion is murder, but then not have consequences for that murder under the law. Otherwise, it's not murder. Therefore, we must classify any intentional killing of unborn children as homicide. We must also understand that providing automatic immunity in all cases to mothers and fathers who have their children intentionally murdered by abortion literally means that do-it-yourself abortions are permissible. And with the abortion industry moving towards self-managed abortion, providing legal penalty only for abortionists accomplishes nothing but actually expedites the abortion industry. Are you still with me?
Yes.
I'm almost done. Okay. Lastly, we must understand that penalties are deterrents to crime. I've spoken with many women who tell me there is nothing wrong with killing their preborn child because abortion facilities are open. And if abortion was so bad, they wouldn't be. Let that thought settle in for a minute. Laws set the people's conscience, and in the case of criminalizing abortion, it would help parents to realize their responsibility is to love and protect their children. And that responsibility doesn't start at birth. It starts at fertilization. If parents knew that they could face homicide charges, they wouldn't kill their children. Together, let's raise the national conscience, starting right here in Maryland. All we lack are legislators and executives with the understanding and commitment to fulfill their own sacred oaths, to provide equal protection for every innocent unborn child, and to check and balance a lawless judiciary. This is the only legal roadmap for ending the abortion holocaust in Maryland. Thank you so much for listening. My prayer is that you would take all that you've heard today and let it move you to action.
Excellent.